You are watching the Elevation Mentor Show, and today I have a very special guest, attorney Richelle. Thank you for being on the show.
Thank you for inviting me. I'm glad to be here.
Okay, so attorney Richelle, I'd like for you to have us tell us who you are and what do you do?
Yes, well, my name is Richelle Lester, and I'm from Detroit, Michigan, born and raised. And I'm an attorney, and I specialize in a lot of different areas. But today we're going to talk about estate planning. So, as you know, I graduated from Cass Technical High School, went on to Western Michigan University to receive a bachelor in political science and also in entrepreneurial management. And I worked for UAW Legal Services for 15 years before I started the law office of Richelle Lester in 2013. And now I'm practicing in various areas, all civil cases, and one area is estate planning.
Okay, go ahead, attorney Richelle from Detroit.
Yes. 7 Mile, look.
What side?
Yes. Yes.
Okay, so tell us more about your business.
So the law office of Richelle Lester specializes in estate planning, probate cases, real estate, and family law. I'm a solo practitioner, but I do have an assistant, and it started in 2013. It's located in the city of Southfield, Michigan.
Okay.
So I handle a lot of different areas. Those are the main ones that I practice in. And I just want to be able to help as many people as I can in every area of law, but especially in estate planning.
Okay. So you work in different areas.
Yes. Yes. And when I started practicing law, one thing about probably any area, but especially in the practice of law, whatever area you start off in, once you start getting experience in it, normally that's where you continue to practice. It's a little more difficult to start something brand new. So I just have been doing these areas for now over 25 years. So I just continue doing what I'm doing and I enjoy it.
Okay. Attorney Richelle, can you tell us why estate planning is important?
So estate planning is very important for several reasons. One reason is that you want to make sure that you make life easier for your family if something were to happen to you. Too many times we have family members or friends that are close to us who pass away and they don't have their affairs in order. Mm-hmm. And it makes the lives of those who have survived you very difficult and very confusing. We want our family, because they'll be grieving the loss of our life, we want them to have peace. We want them to have direction. We don't want to leave them in a whirlspin, spinning around trying to find out what assets did you have? Where did you have accounts? How much was in it? Were there beneficiaries on it? If you have an estate plan, it will make your family lives easier if something were to happen to you. And most people who don't do that, if you do not have an estate plan in place, guess who's going to make the decisions about who gets your assets? A judge. And estate planning doesn't just include what happens to your estate after death. It also includes what happens during your lifetime. If you ever become incapacitated while you're alive, who's going to make sure your bills are paid? Who's going to make sure your home is kept? Who's going to handle your financial affairs during your lifetime? If you don't nominate someone to handle those affairs, a judge will. And a lot of times a judge may appoint someone who you may not even want, you may not even like, or someone you may not even trust. But if you did not make those decisions when you were of sound mind, a judge will. And you may not like the decisions they may make. So that's why it's important to get your affairs in order, make sure everything is together, make sure your family knows where your paperwork is. You know, I tell my clients, tell your family, after we've done a beautiful estate plan, please tell your family, if anything happens to me, my important documents are, and you fill in the blank. Is it in a safe deposit box? Is it in a safe at your home? Is it in a file cabinet at your home? Is it in a probate court for safekeeping? Tell someone where your important documents are so that they won't be confused and think you don't have anything.
That is
So,
very good information.
yes,
So people don't have their affairs in order.
correct. And the important thing is to remember, no matter how much or how little you have, you still need to have your affairs in order. You know, I tell some of my clients, you never know. You may hit the lottery. You may get an inheritance. You may win a lawsuit. And right now you may think you have nothing, but in the future, you have no idea the way the course of your life is going to go. So be optimistic, believe that you're going to have something, and then plan for it. And set up your plan, your estate plan through an attorney.
Okay. All
and
right.
not use the documents online because, and I just wanted to interject that as well, not to use certain products or things that you may find on the internet because it's not one size fit all. And sometimes those documents are not catered to the state that you live in. And it may not, you don't have that advice that you're getting from an attorney on how to draft everything when you do it on your own. So make sure you get an attorney who specializes in estate planning, who can create an estate plan that's designed perfectly for you and your family.
Okay. Very good information. So, Attorney Richelle, could you talk about some of the services that you offer? Like, can you give some definitions on some of the things, some of the
Sure.
terms?
Yeah. So one thing that most people think of when they think of estate planning is a will. And a will gives instructions on how you want to divide your assets at the time of death. Every will has to go through probate court. Most people do not realize that every will has to go through probate court because a probate court judge has to determine that the will is valid, has to determine that the person that you nominated to be in charge of your estate is fit and proper, and has to determine who are your heirs. So that's a will. A will applies to any assets that are in your name alone.
Okay.
Any assets in your name by itself with no beneficiary and no co-owner. That's what a will applies to. The second document that most people are familiar with is a living trust. And a living trust is a document, just like a will, that explains what happens to your estate at the time of death. In a trust, you name a successor trustee who will be in charge of the trust, and then you can say how you want everything to be divided. A trust, however, is more complicated than a will, because with a trust, you have to change the title of everything that you own into a trust name. In other words, you have to fund the trust. So you have to change all of your assets, your savings accounts, checking accounts, money market accounts, mutual funds or stocks. Any assets that you have to be put into this new trust name in order for it to be effective. And that, to some people, is complicated. Some people don't understand that concept. Some people procrastinate, and they may sign a trust, but never change everything into the trust name. So the trust has to be funded in order for it to be effective. And if a trust is not properly funded, your estate could end up in probate court. But a trust is drafted to avoid probate court. So a well-drafted living trust can avoid the probate court process. Also included in an estate plan are powers of attorney. And I normally handle 2 powers of attorney, a power of attorney for finance and a power of attorney for healthcare. And powers of attorney are only good while you're alive. In a power of attorney, you nominate who would make decisions concerning your finances if you're ever disabled, incapacitated, or considered to be incompetent. In that power of attorney, you nominate the person you trust, and they would be able to make decisions and to be able to make sure your bills are paid if something were to happen to you during your lifetime, if you're ever unable to do so yourself. And the healthcare power of attorney says who you would want to handle your medical decisions if you're unable to do so. I also do a living will, which is a declaration that says if you make a decision, if there's ever a decision that has to be made, if you have a terminal illness or an irreversible condition where doctors say the death is imminent, the declaration or the living will says, please do not hook me up to life support if all it's going to do is prolong the dying process. I also draft a HIPAA form, which tells doctors it's okay to talk to the person you've nominated concerning your medical treatment and care. And I also prepare a ladybird deed, which is a quitclaim deed. And that's something that's specific here in Michigan that we draft to prevent real estate from going into probate court. So when I meet with clients, I tell them the 4 ways that they can avoid probate court. And then I provide all of those, the documents that I just mentioned as possible documents to help them have an estate plan.
That is very good information.
Thank you.
How to avoid probate court.
Yes. Yes. And all of my clients, I teach them how to avoid probate court, which most people are aware can be very costly and very time consuming, or it can take a long time. But it can be doable. Your estate can go through probate court. There can be people have probably heard nightmares about probate court. And that normally happens if their family members are fighting and disputing on how things should be divided, who should be in charge, and whether the person who's in charge is doing what they're supposed to do.
Mm-hmm.
So we try to avoid probate court if at all possible.
Okay. Attorney Richelle, so out of the services that you offer, which one would you say is the most important?
Now that's a hard question, because the reason why I say that's a hard question is I've had clients that will come to me and say, all I want is a power of attorney for finance. That's it. That's all I need right now. So let's just do that. And then 2 years later, I get a call from their child saying, can we do a power of attorney for healthcare? They're in a coma. And I'm like, no, because they have to sign the document. I can't have them do that if they're in a coma. So it's really hard to say which one is the most important. I would say all of them are the most important, to have them all together, so that if anything happens in your life, you're protected and you're covered. But if I did have to choose one, I would say the financial power of attorney probably would be the most important, but it all depends on everyone's circumstance. So make sure you have everything covered, all bases covered.
Okay. Because I've seen some people go for a trust over a will, like things like that.
Yes, and some people do a trust because they want to say, oh, I've got a living trust. Yes, I put everything into my trust. And they don't even understand what it means, and they haven't funded it. So it's useless. So if you do a trust, You need to make sure you understand it and that you funded your trust, or your trust will be useless. It will be a perfectly drafted, expensive document, because it's more expensive for an attorney to draft a trust than a will. And you could spend thousands of dollars doing a trust that means absolutely nothing. But a trust is not always the best for everybody. There are some clients of mine, because of the extra work that has to be done for it, it's not really beneficial for them to have it because it's too complicated for them to be able to understand it. And I don't want a client to have a document that they don't understand, or they don't know what to do with it. So a trust is not always the best thing for everyone. It's not one size fit all. It's not like a trust is good for everyone. I normally recommend a living trust if you have minor children, because in a living trust, you can be very detailed concerning the inheritance for your minor children. Because in Michigan, most states, once a child reaches the age of 18, they will receive their full inheritance. And most people believe that an 18-year-old, if they receive thousands of dollars from an inheritance, they'll just buy a Corvette, take all of their friends to Cancun, and all the money will be gone in less than 6 months. So with a living trust, you can be creative, and you can put someone else that you trust to be in charge of their inheritance until they're older than 18, such as 21, 25, sometimes even 30. And that person will make sure that the funds are being properly used for your child's education, support, if they want to start a business, if they need to buy a house, until they reach whatever age you put in the trust, that they're mature, where they will be mature enough to handle their assets on their own. So a trust is good, but it's not for everyone. But I advise it for those who have minor children.
Okay, that makes sense. That makes a lot of sense. So Attorney Richelle, about what age are the people that come to you, and do you find that a lot of people procrastinate on doing this?
Yes, I find a lot of people procrastinate. It used to be that most of my clients who would come in would probably be 60 and up, because that's when people start thinking about, okay, how do I want things set up for my family? So that's the general age group. But I believe people should do an estate plan as soon as you can, because you can always change your estate plan as life changes, as it progresses. And none of us have any idea how long we're going to be here on this earth. So it's better to have it now rather than procrastinate. And as I mentioned before, I've had people who procrastinate, and their family members call me when they've been admitted to hospice, and they don't even know what day it is, and they can't read a document, understand it, and sign it. And I've had to reject some clients or potential clients because the person was not mentally competent. So procrastinating can lead to your estate not being prepared at all. And once again, if your estate is not prepared, a judge who doesn't know you, who doesn't know your family, who doesn't know what's best for you, will make a decision on what happens to your assets. And it's possible, if you don't have everything set up, it may go to that one relative who is on drugs, or a relative who's a spendthrift who spends all their money. So make sure you have your affairs in order so you can direct who gets what from your assets without procrastinating.
Okay, sounds good, attorney. So I would like to ask you, how does the actual process work, and what kind of documents and forms do you have to bring?
So I initially send a questionnaire to every client for them to complete, and that will give them an idea to start thinking about. Who are my family members? Who do I want to get an inheritance in my will? What assets do I have? How do I want it all divided? After they complete the questionnaire, I need the questionnaire to be returned to me with a deed if they have real estate, any previously signed wills or trusts, And if they have any other documents they would like for me to review, I can review that as well. But normally that's what I need: the questionnaire, the deed to their home, and if they have any previously signed wills or powers of attorney. And from there, we do a consultation. We talk about all of their options, and then we decide they can decide what's best for them.
Okay. Sounds good. So, as far as their personal business, how personal does it get? And do you find out all of their debts and you find out everything that they own and everything that they have debts for?
I do, in the questionnaire, I do ask for all of their assets. I normally do not ask for their debts because I'm not a financial planner, so I can't advise them on handling their debts. But in order for me to prepare a well-crafted estate plan, I need to know what assets they have so I can give them the proper advice. And I also give them a list of their assets so that once they leave my office, they will know exactly what they have on paper. Believe it or not, most people don't realize how much they really have. They may say, all I have is a checking account. However, when I go through the questionnaire and I start asking more questions, I find out, okay, maybe they have a Robinhood account or an Acorns account or other things that they didn't consider would even be considered part of an estate plan. And life insurance policies that they may have forgotten about. So the attorney needs as much information, accurate and true information about all of your assets in order to prepare the best estate plan for you. And it can get personal because I ask how much is in your accounts, because I also add up the grand total of what your estate is worth. Most people don't know how much their estate is worth, and it may shock some people. Once again, people may not do an estate plan because they think they have nothing. But once I sit down with them and list all of their assets and the total of their assets, they have more than what they actually think. And we also do that so that on their demise, their children will know what they have, how much they have, and where to get started. So, and I've had some clients who are reluctant to disclose everything to me, and I just have to let them know, if you don't disclose everything, I can't do the best estate plan for you.
Okay. You kind of answered the question, but what if people don't want you in their business?
So I will tell people I can't do the best estate plan for you without knowing all of your assets. But I've also had clients sign forms that says I did not disclose all of my assets, during the interview, just so that it's very clear if anything happens that if we have to go to court, if something happens to them, that the judge will know and their family will know that they didn't give their attorney all of their information. So if this estate plan seems to be incomplete, it's because they failed to disclose all of their assets. And not because if you don't put something, disclose everything, it could look like you're incompetent. If the children say, what? They didn't tell the attorney they had, $100,000 in this bank. It gives a question as to whether the person was competent or not. So if we sign something saying I do not want to disclose all of my assets, then it lets everyone know it was intentional.
Okay. Good information. Attorney Richelle, so about how long does this process take to set up the estate plan?
It takes an average of 30 days from the time that I send out the questionnaire until the day that they sign it. And it can take much shorter time, depending on how quickly I can get the questionnaire back and interview the client. And it may take longer if the client is not clear on how they want to set everything up. Okay. So on average, around 30 days from beginning to end.
Okay, very good. So I'm going to switch over to Love. So, Attorney Richelle, are you single or married?
I'm single.
Can you tell us one thing you learned about money as it pertains to relationships that could help somebody else?
Yes. So when it comes to finances, we know that that's the leading cause for divorce. And it's really about how people feel about money. I believe that in a relationship, if you're married, you should disclose and talk about money matters. You need to know what each other has. One of my very first estate planning clients was a widowed woman who came in after her husband passed away. She came in and I went through my questionnaire with her. She had no clue of what assets she and her husband had. And she cried in my office because she was embarrassed and she was scared because she said, I have no idea. I don't know who we bank with. I don't know how much is in the bank account. So full disclosure is necessary in a relationship, in a marriage. So that's the number one thing to, and even if one person is handling the finances, the person who's not handling the finances, there needs to be a meeting to determine how things are handled with the finances in a household. So it's very important to disclose. Communication is key. Communicating and disclosing everything you have.
Okay. What is your favorite book, Attorney Richelle?
The Bible, and I know that probably sounds cliche-ish, but it's true. Any financial matters are in the Bible. Any issue you can think of is in the Bible, and it gives wisdom, direction, guidance for my life. So the Bible is my favorite book.
Okay. Um, Rochelle, where can people contact you if they would like to reach out to you and learn more?
Yes, so my office phone number is probably the one of the best ways to reach me. And the phone number is 248-915-8990, or by email. And my email is attorneyrachelle@gmail.com. That's attorney spelled out, and then my first name, Richelle, RICHELLE@gmail.com, or my website, www.attorneyrachelle.com.
Okay, Attorney Rochelle, and the last question, did you have any last words to leave for the audience?
Yes, the main thing that I would like for people to know is to please prepare an estate plan through an attorney. Make sure you have your affairs in order so that it makes it easier for your family if something were to happen to you. You want to leave a legacy. You want to leave generational wealth to the next generation. You don't want your family to be lost or confused of what to do if something were to happen to you. You want to make sure that your family is well taken care of if something happens to you. And you don't want them to feel lost as to what to do. So make sure you have a will. I always do a will as a backup, whether we do other estate planning documents. I always do a will. So make sure you also have a financial and healthcare power of attorneys, a HIPAA form, and a Lady Bird deed if you're here in Michigan. And consider a living trust if you do have minor children. Make sure you have an estate plan to cover every aspect of your life to make it like the lives of your loved ones easier.
Sounds good. Thank you so much for being on the show, Attorney Rochelle.
Thanks for inviting me. I had fun.